This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Welcome to Discussions at the Round Table. I'm your host, Noah Ballmer. Today's guest is Rob Aft. Rob is the president of Compliance Consulting LLC, a media consulting outfit out of Los Angeles, California, with high-profile clients ranging from Peter Jackson to the Directors Guild of America. Additionally, he has served previously as the president of international distribution at the Kushner Law Company and is senior VP of MDP Worldwide. Rob has taught film business courses at numerous universities and is a published author in the films industry in books, papers, and articles. Rob, thank you so much for joining me here today. I'm really excited to have you on the show.
Thank you, Noah. It's a fun chance for me to talk about something that I try to recruit people into all the time, and they find a lot of the early stages challenging because
Sure.
I often think they just don't understand why they're an important part of the process.
Well, let's jump into it then. You know, you've been consulting in the films industry for over 2 decades now, it looks like. Have you always had a passion for film? How did you first break into the industry?
Oh no. Oh no, I did not get into it because I always tell people we have about 3,000 books in the house and about 20 DVDs. And and most of those are still in the plastic. Now I come from more of a book background, and I got into the film industry to travel. I'd been living overseas in Spain, Mexico, a couple of years in France, and tried to think of a way I could continue to travel and have a job in the US. And I happened to stumble on the film industry while I was working as a translator in Paris and became aware of this whole network of festivals and markets where you get to go to the south of France 2 or 3 times a year, depending on your business. And you
Sounds
get to
all
go
right.
to, not only the major markets, but you also go to festivals, Toronto and Tokyo and Sundance, wherever those are happening. And you're working, you're doing business, but it's still travel, and that's why I got into it.
Sure. And so you went from kind of a travel-minded literary guy into the films consulting industry, and you've been doing that ever since.
Well,
So
just to clarify, I started as a sales agent,
okay.
selling, licensing U.S. or English language movies to distributors around the world. And so I did that for 12 years, and then I got into consulting.
So when you became a consultant, how did you parlay that experience into being an expert or an expert witness?
Well, during the time that I was functioning as a sales agent, one of the things about the independent world is that you often don't have the support that you might at a studio, and you also have legal departments that are much more interested in working on productions, which they think is the fun part, instead of sales contracts and mediation, arbitration, collecting monies, whatever the legal issues are. And so I had to do all that kind of thing myself. I had to interface with the banks for loans. I had to work with attorneys on all kinds of agreements. And so learning about all of these different aspects of the business were important for me to have the kind of background where I could do an analysis of legal documents if I had to. I can't function as a lawyer. I'm not an attorney, but I can read a contract, and I can
Sure.
talk about how that contract is implemented in the real world, which is I think that for me I've come up against on the other side. There have been experts who are more academics and look at things from a theoretical standpoint, but having the
Right.
practical experience is what I really think is most convincing and important.
So were you first approached by somebody, or did you kind of market yourself as an expert?
No, I've never marketed myself as an expert. I just happen to know a lot of people in the industry. I was made it a point of meeting people, getting to know them, getting to know about their businesses, and so I,
Networking.
I yeah, networking and I some lawyers that I had worked with mentioned that there was a litigation happening in an area that I was very familiar with. It was had to do with non-payment of revenues that were due to a producer. And so the law firm engaged me and did an amazing job explaining to me uh, how how an expert witness should behave, what their role is, how to deal with depositions. In that case, I actually had to testify in court as well. I had a deposition and testified in court. And I enjoyed the experience. I enjoyed sharing knowledge, but I also enjoyed the back and forth with the attorneys, and these were attorneys that agreed to be educated, which is the other thing is that I'm often attorneys don't understand the topic. They're litigators. They're not
Sure.
film industry experts, for example. They need the experts to tell them how the industry works, and I enjoyed that.
Right. And, that touches on the things that we've talked about before. So, Rob and I have spoken before, and he has a lot of great advice for experts, both starting out and ones that are well into their career, and in attorneys also, or in particular. So, let's go through some of those observations and recommendations. And if you have a story to drive any of these home, all the better. One of the things you were telling me about is how important it is to tell the truth, but to also stay in your lane. What do you mean by that?
Well, telling the truth is fundamental to being a good expert witness. You
Right.
don't serve your client's interests by trying to be an advocate for them. You destroy your own credibility, and uh, yeah, your whatever you're bringing to the table is not worth anything to your client as soon as your credibility is destroyed. So you have to tell the truth even when it is not necessarily in your client's favor,
Sure.
and also tell the truth to the attorneys you're working with. Point out weaknesses in their case, and so telling the truth is fundamental. You're also under oath. It's illegal while you're under oath to lie, and so there's that. I don't know if anyone's ever been prosecuted for perjury during a as expert witness testimony, but and then stay in your lane. Don't claim to have expertise in an area where you clearly don't.
Right.
That is the easiest way to wreck your credibility as well. Assume that the other party has experts who are at least as good, if not better, than you are, and more knowledgeable, more experienced, whatever it is. Just assume that that's the advice they're getting, and if you step out of your area of expertise and offer an opinion on something that you don't really understand or know about, you're going to get caught. There's kind of no way around it. The other side's experts or the lawyers themselves. Someone is going to say he has no idea what he's talking about, and then you'll be grilled on why you think you're an expert in that area, and your credibility will collapse.
And that they're doing, or they may be doing, oppositional research prior to the case, right? So they're already looking to kind of impeach the other side's witnesses to begin with.
Absolutely, I think that's incumbent on not just the attorneys, but I'll do some of the same work. I uh, there are there are a lot of ways to obtain information about the other side's witnesses that could serve to harm their credibility. And not all of those are obvious or open to the attorneys involved. Often I know that, in most cases, I think I know the other side's expert
Because they're in the same industry.
personally, and you're right, and so I know what their history is, what they've done, often what they've written, and if that contradicts something that they're saying, then I think it's my role also to point that out. And in support of my own opinions. So
Sure.
my opinion is this, and actually my opinion is supported by the other side's experts' writings. That's happened a number of times. So I'll cite the other side's expert in support of my opinions, and it's really hard for the other side to defend, and it also hurts their credibility if they're changing opinions based on whether or not they're being paid as an expert.
And I guess the other side of the coin is you need to make sure that if you have a large body of work behind you for, in your case, 20 years to recall what you've said in the past, to not contradict it by accident. Maybe even your opinion has changed or your understanding of something has changed since you've written on it in the past.
Well, the industry is constantly changing.
Sure.
And that's something that I've addressed often in writing. I recently the UN. I do a lot of work with the UN's World Intellectual Property Organization, and have recently published a second edition of a book called "From Script to Screen: Copyright in the Film Industry" or something. I always forget what the title is. It's a free publication, easy to download, and there's a reason that there's a second edition. 12 years I think passed between editions, and during that time, streaming services came in, geopolitical reality shifted, the
Sure.
change in the Chinese marketplace there, and also the way contracts are negotiated and deliveries are made. There's so many different things. Fundamentally, the business usually remains pretty consistent in
Right.
terms of contracts and licensing and a lot of things I have opinions on and distribution, but um, it changes. So opinions need to change and need to evolve, but within that scope, like you said, you have to be careful of contradicting yourself and and knowing the information that the other party is going to have on you, and so you need to be able to defend yourself.
Along those lines, speaking of opinions, you were telling me about, the way that a good attorney won't tell you what your opinion is. They'll incorporate your opinion into the case. Have you been on the receiving end of an attorney not doing a good job at that, where they're trying to influence what your opinion is on the thing that you're an expert in?
Yes, I think the best attorneys do that the least, and but all attorneys at some level would like your opinion to fit their narrative and help their client, and that it's always a delicate balance. I don't if someone will directly says to me, well, we'd really like you to be able to say it like that, I'll think for a minute, and if that is the truth, if I say it like that, and because I might be coming at something from a academic or an angle that doesn't, that's hard for a judge or jury to understand, or an
Sure.
arbitrator, and they might say, okay, yeah, I get what you're saying, but it sounds like word salad to most people. So how can you explain that in a better way? And in terms of feeding me an opinion, it rarely happens because attorneys kind of know that isn't the way I would work, and I most of the time I'm able, yeah, most of the time where I'm asked directly to have an opinion of one type or another, I reject it out of hand.
Right.
But I do take into consideration that the narrative is a certain thing, because you've got, when you're looking at 100-page inter-party agreement, I have lots of opinions about that. How many of those are relevant to the issue? I'm not sure. So I do have to listen to the attorneys when they say, well, that was something that was arbitrated in a previous matter and it's no longer relevant.
Right.
Fine.
Let's pivot to confidentiality. We were talking about confidentiality issues and discovery, and it's something that you have to always be aware of. Tell me a little bit about that.
Well, there's information being shared with the experts that is always discoverable. So if
Right.
something's coming your way, I'm not aware of any reason or any excuse you would have not to divulge that during a deposition or the subpoenas all say what information you received, and you have to give them that information. It's not you don't have a choice. And then when you're corresponding with the attorneys, most of that is discoverable. I've been told that drafts of reports are often not discoverable these days. When I started doing this, I was under the impression that all drafts of reports were discoverable.
Oh, okay.
And but now I've been told that maybe not. Anyway, I will always defer to the attorneys on matters like that and just say, look, if I send you this report by email, is that discoverable? And if
Hmm.
they say no, then I, then it's not that then I do not hand it over. But generally, everything is discoverable. Conversations with the attorneys, conversations with your client, which you probably should never have, are all discoverable. And it's a pain in the butt, and especially if you have to take notes to remember things, which when you're my age you do, and those are all everything's discoverable. So be careful what you write down. To be careful what you say to people. Always assume that there's somebody in the room that took a note that said something that is going to be offered in discovery.
Do you feel that the attorneys that you've worked with have adequately prepared you for that? Let you know what is and isn't discoverable, what to maintain, what to record, etc.
It's interesting because I often have these arguments with them up front. I've had attorneys that said, "Look, we're going to get on the phone with the client." I say, "What? I don't want to talk to the client." Um, yeah, there's yeah, the client is more likely to try to influence my opinion than anyone, and then I have to divulge that.
Right.
I can't. Yeah, they'll say, "So you talked to the client on this day?" Yes, I did. Well, what did they tell you? Well, they told me they wanted me to lie on the stand. That doesn't look
Right.
good. Whereas the attorneys understand that they shouldn't do that. So I have dealt with attorneys that didn't understand discovery issues, especially if they weren't themselves litigators. And then I've had attorneys that are just excellent in. I like it when the attorneys prepare all of the material. Sometimes I'm sent a massive amount of paperwork, and I don't want to have to list every bit of it by Bates number and whatever. I kind of expect the attorneys to prepare that part. If I've done outside research on my own, of course I have to prepare that.
Sure.
But in terms of what I've been given, please just keep a list. I assume they keep a list and they turn that over. So
When you're prepared by your attorney, um, how incumbent is it upon you to research aspects of your area of your field that might pertain to the case that you don't have current knowledge? In other words, how do you maintain not only being an expert, but being an expert in the specific matter of that case?
that's an excellent question. I go to film markets, film festivals. I have many friends who are bankers, lawyers, sales agents, producers. Tomorrow I've got lunch with a producer and a sales agent, and we will discuss the marketplace and we'll discuss aspects of how are contracts changing in the streaming world? Um, how are people dealing with the allocation of receipts? Oh, yeah, all those. It's a natural, almost a pattern you get into with people. It's sort of like asking, so how's business?
Right.
And which I do often too, and it often is really depressing to hear. But so I keep up with all of that, and then of course reading the trades, reading the literature that is that surrounds it. I read a UN report yesterday that was very long that had a lot of what I considered irrelevant information in it, but I plowed through it, and so that's how you keep up. You have to keep up that way in order to have relevant opinions. But there was another part to that question.
Uh,
Um,
well, yeah, it's being on top of it, not only vis-a-vis your field in general, but with respect to the particulars of the case at hand.
right, right, and in often the cases involve people I know or um, things where I can either suggest to the attorneys to contact someone directly and say, look, I think so and so will probably have relevant information. They could probably clarify this issue, especially if it's outside my area of expertise.
Sure.
So, and then in terms of outside specific information, I'll always check things like the uh, IFTA, the International Film and Television Alliance database of arbitration decisions, because attorneys often don't do that, and that will list the parties to arbitrations. If someone is constantly arbitrating and or constantly getting into legal disputes, and if that if that person lost, let's say, to another company where I know the principals, I'll call the principals and say, "So what happened? What was the dispute? What uh, what was your experience with this dispute with the other side's attorneys? Who were the attorneys? Are they using the same ones? Why do you think you won?" I mean, there are a lot of topics that I can reach out to people within the industry on a specific case and get relevant information. And of course, those discussions are discoverable. So if you find out something that's not good, then
You have to.
that's the danger.
So it seems like, along those lines, you really do take a very proactive role as an expert. Is that something that when you were first kind of learning the ropes of this, is that something that you were initially told that you should, make sure you're doing your own research and challenging some of the things that the attorney says and being, preparing yourself on your own terms and asking lots of questions, things like that? Were you prepared for that, or is that something that you kind of learned along the way? And what would you say to newer experts who aren't sure exactly, how deep they need to dive in, how much they have to self-direct?
Uh, I would say that expect the other side is extremely prepared, and the more prepared you are, the better. So I'm a natural researcher. It's just in my nature to conduct a huge amount of research. When I was selling movies, I wouldn't set prices based on, oh, the budget of the movie is this, and Germany pays 10% of that, so that's the price. I I would research which client is more likely to buy this, which what are they going to do with it? Is this cast better for Germany? What other movies have they been in that might have performed? I always did research. I can't help it. So when cases would come up, I would do the research, and I also am too much of a teacher.
Mm-hmm.
Experts should not be professors. That's one of the maxims is don't teach. Answer the question. Don't teach. But if there were things that I thought that the lawyers should know about the way the industry works, especially if they've gotten it wrong, then yeah, I would. So I think I did that right from the beginning, and I wasn't. And luckily, I was working with an attorney named Larry Stein and Ann Loeb, and they were excellent. Ann has passed away, unfortunately, and I think Larry is retired. But yeah, they accepted my opinions as relevant, and were happy to yeah, not just opinions but also my knowledge, expertise,
Sure.
experience, and relationships. They looked at all those and said, yeah, this guy has something that we need to know to uh, to understand this case in general.
Before we wrap up, I want to talk to you about one more thing that we've discussed, which is getting paid. That's not something that I've talked about on this show before. Tell me about getting paid in advance. And you said that it's to remember that you get paid for all of your time. Your time is valuable. So I'd like to hear a little bit about that before we wrap up.
Well, and you are getting paid for your time. You're not getting paid for your opinion. That's a
Right.
that's a trick question that you get told up front. That's they'll try to say, how much are you getting paid for your opinion? And you're getting paid for your time, not your opinion. Yeah, it's keep careful records and get a retainer just to make sure that the client is serious. And I usually don't have a rolling retainer, so my final payment is often a little up in the air. I've been very lucky that clients have paid me, but sometimes that final payment can take quite a while. And in a deposition situation, it should be very, very clear the other side is paying you. The other side has asked you to be somewhere at a certain point in time and asked you to leave at a certain point in time. They need to pay you for every minute of that. If there's a question in your mind, not your attorney's mind, but in your
Mhm.
mind that they might not be handing you a check that day, get it up front. Have them say, look, you'll probably be here for 2 hours. Here's a check for 2 hours. And it should be clear, and the attorney that you're working with should make it clear that payment will be made uh, up front if necessary. And you need to make it clear to the attorneys that if for some reason you aren't paid by the opposing party for your time, that your client will be covering the bill for your time. And so that's but getting paid is more of an art than I actually wrote a chapter for the movie business book called Getting Paid.
Oh yeah.
And and so you need to know what leverage you have and how best, but it's challenging sometimes.
Is it difficult just to broach the topic at all with an attorney?
No, because attorneys inevitably, yeah, I won't get into my billing, but in almost every case, junior associates at the firm are making more per hour than I am,
Right.
and so I have no qualms about telling $1,000 an hour attorney that I really would like to get paid, and this is my bill. People don't complain about my bills because I tend to be very conservative in billing. And I've seen bills because the bills are discoverable. I've seen bills from
Right.
other experts that have shocked me, where I thought you spent 40 hours working on this 2-page report that has nothing substantive in it. Wow. Are you are either the slowest person on the planet, or this is padded somehow. So I don't pad my hours. I I also don't. The funny thing, and I always tell the attorneys this, they say bill for those hours. I say if I had to read a document that took me 3 hours to read, and then 3 months later I have to read it again, which often happens because you're
Mhm.
preparing for trial, you're preparing for, or you're writing a report or whatever. I don't charge you
Sure.
a second time. I don't charge you twice for reading the same document, and
Right.
because I forgot something or I need to find, yeah, or if there's one, I've spent hours looking for one specific line in a deposition that I knew had to be there. I don't. charge somebody hours of because I can't find something. But
That's a fuzzy line, though.
attorneys
That's a
tell
little
me
bit
to.
difficult.
Yeah,
The attorneys tell you to.
yeah, because they do.
Right.
They bill
Oh, you
15
know they
minutes for
do.
thinking about something while they're taking a shower. That's but whatever.
Rob, do you have any last minute advice before we sign this one off?
Uh, I have fun with it. In a lot of ways, it is a game, and or it's treated as a game by the attorneys. It's like a chess game. And if an attorney's yelling at you or questioning your parentage, uh, don't fall for it. They're trying to get a rise out of you. You are there to calmly and completely provide information and opinions about, well, mainly just opinions. The information might come with the opinions, but that's your job. Your job is not to uh, get mad or complain about the tactics that the other attorney is using. Let you always have someone from the law firm there. I guess they call it defending your deposition, and or objecting if it's in court or at an arbitration, and let them have the fights
Right.
and but just sit there quietly until the fight's resolved. This person doesn't know you. They don't know your mother. They don't whatever they think they have on you. If they do have something on you, then yeah, be worried about that. But don't fall for any of that. Just answer the questions completely and thoroughly. Don't embellish. Don't teach. And have fun with it. I enjoy those interactions. I really I have something I need to communicate to somebody who's interested, hopefully, in hearing what I have to say. And I think I'm pretty good at it. So I guess that would be my advice. Enjoy it.
Well, I think that that is great advice, and I think that you are very good at it. Thank you so much for being on the show today, Rob.
No, thank you, Noah. Okay, you take care.
This is Noah Ballmer, and we are signing off another discussion at the roundtable. See you next time.
Thank you for listening to our podcast, Discussions at Roundtable. Our show notes are available on our website, roundtablegroup.com. Subscribe today on Apple Podcasts or your favorite listening apps.